Yeah, ready? Sorry, guys. Dude, we'll call the meeting to order. It's 3:37. And what's that, Clara? Roll call from you?
Okay, Chair Imler will not be in the meeting today. She did call today. Do the roll call. Vice Chair Christina Ponte,
Present.
Commissioner Contrell,
Present.
Commissioner Tilka,
Yeah.
Commissioner McLaughlin.
Present.
Okay, next up is public comment. If anybody has any public comment, come to the podium. Hearing none, we'll move on to the approval.
I'm just looking.
Oh, do you have a packet?
I'm good.
Approval of the minutes from last meeting.
I'll make a motion to approve the minute.
I second.
Commissioner Tilka,
Yes.
Commissioner Cantrell,
Yes.
Vice Chair Ponte,
Yes.
Commissioner McLaughlin.
Can I abstain? Because I wasn't at the meeting to be able to double check that
Were you
anything's
able-
incorrect.
You were able to read the minutes?
Yes.
Okay, you can.
All right, then I approve.
The motion carried 4-0.
All right. Next, we'll move on to old business. So this is where I'm going to look to you, Jerry, to pick us back up where we left off.
Okay, we were last on Personnel Policy Rules and Procedures Manual under the Employment Section I, which is in the original packet that was shared. I think it was it the last time or the time before this was shared? I think it was the last time, right? Yes. We're on, it's item 5A, page 46 at the bottom, page 46 where we're at. We read through item I, employment, subsection A, non-temporary regular employment, and then subset 2. We had made it through there, and from this point, we'd be starting out on item 3, which is applicants for city employment. Does anybody need time to find this document?
I did want to mention that it was said at the last meeting, there is no update to the manual in the agenda packet because they asked that it not be. So I don't know if you have anything to follow.
No, is it possible to put the last version up on the screen?
Is it in, where would I find it online?
Be the last agenda packet. The last agenda packet. Yes, September 13th.
13th.
Be on page 46. Bottom is page 46. It's item 5A of the document.
And is it possible to put it up on the screen? Is that something we could do?
I don't know.
Who
Let me go
controls the
back and
display?
ask Tom.
Okay.
He should be able to do it. Hold on.
Not in the right document.
And my understanding from the last meeting was Attorney Eichenfelder, you're taking down the changes and at the end you'll implement them. Excellent. And we'll proceed as you guys did the last time. I think by the end, we were just pulling the section up. You didn't have to read, Jerry, and we just had any discussion or comments.
Oh, why did it come up with very low battery? It would be OneDrive, Documents, CSE. 3, there we go. Personnel policy. Right one.
Okay, I do the same. Excellent. Thank you.
Figured that was gonna be a problem. It was mentioned by a couple of people.
I'll do that. Okay.
They're setting it up.
I mean, I don't mind you reading if you like reading. It's up to you.
They did ask me, she just said, because they don't have,
Okay,
they asked me if I would read something.
okay.
I did testing for 4 hours a day, I was reading.
Okay. It makes it easier to hear it out loud, honestly.
You said 43, correct?
It's page 46 on the packet.
46.
It's I-1.
And then is this what we're using at our next meeting also, this, so I should say this one tonight?
Absolutely. Are you ready?
I'm ready. Is that the correct,
That's,
Up on the
it needs to be one page prior to it on the
That's
display.
it, non-temporary.
It's number 8. We're actually on item number 3 in that section. There we go. I'm going to go ahead and read. Is that okay? All right. Applicants for the city employment apply to Human Resources Department in the form and manner, including electronic application submission as the department designates. Applicants who make initial contact with the individual city department and/or application/resumes received by the city departments shall immediately be directed to the Human Resources Department. The Human Resources staff or designee may grant exceptions for certain special programs. I have one concern, and that's it's not spelled out inside of here what certain special programs are. That's the only reference to special programs in the whole document.
I also was curious what the reference to special programs is.
Yep.
And in what case you wouldn't need to follow the above. And Attorney Eichenfelder, is that something you can address for us?
Let me read it. Well, so, this would be kind of rare, but let's say one of our departments does a special program that's in joint with Pinellas County or with a nonprofit, and it's not really, it's less formal than a permanent city position. At times, the director could just say, yeah, in other words, you wouldn't go through the normal process, but,
This is,
it-
this says non-temporary employment, though, so that doesn't seem like that would qualify in that
yeah,
section.
I think, let's just take that sentence out.
Okay,
Okay,
very good.
all right. Do you guys agree? All right. Is it okay to move forward to the next?
Yep.
Item 4, applicants are accepted for announced openings during the published advertising period.
No comment.
No comment. You guys good? Item 5, once a position has been filled, the position is closed. Should one or more of the same positions come open again within 90 days after the first being filled, a department may make an offer to the next most qualified candidate from among the original applications. Alternatively, or if the vacancy arises more than 60 days later, the position will, absent an exception approved by Human Resources staff, be re-advertised and new applications sought. This puzzles me because you got one where it says 90 days, but then it says 60 days. So I made a comment on mine, and but I don't. Within 90 days after first being filled, the department may take the next most qualified candidate.
That makes sense to me.
That makes sense through there.
1 and 2.
Alternatively,
If the vacancy arises more than 60 days later, the position.
is that after the 90 days, or is that?
I think the alternative is giving you this choice on the 90 or the 60, but there seems to be some.
Oh, okay, so within the first 90 days, you can pull from the original pool, or you have to allow at least 60 days. So I think the second sentence, or third sentence could be revised to be more clear, if that's the intention, is to say you can re-advertise, but you must allot for at least 60 days. Is that, okay,
Okay, I'll try to reword it.
reword the third sentence.
So it sounds to me like the idea, so I understand, is that the first 60 days you definitely take from that pool of people that have already been interviewed. Is
So
that
the-
correct?
The position is closed, you need, and then it becomes that you need to, yeah, the 60 days you can pull from the original pool.
6 days, you should just go ahead and take from the original search.
What
Can be
I'm,
extended to 90 days if approved by HR.
what I'm understanding is within 90 days, you're allowed to pull from the original applicant pool.
Correct.
If you don't want to consider that pool, you have to wait at least 60 days to re-advertise.
Correct.
So the first 60 days you have to pull from the pool.
Yeah.
It's the next 30.
Yes.
The next
You- sorry,
30,
yes.
you either have to advertise or pull, but it's up to Human Resources, correct?
Correct. I mean, I think I'll try to word it better, but the intent is twofold. One is an efficiency thing. You don't want to keep re-advertising so soon after you re-advertise, because theoretically, you've got a pool of people who are interested and applied. But then there's also we don't want departments playing monkey business, and so they got an applicant pool, and they didn't see their desired person in the applicant pool because they didn't get their application in on time or whatever. And so sometimes I've encountered where the department would say, oh, we must go advertise,
Or-
again, so as to let the person that they're really looking for to apply. And that's not fair to those who put their application in a timely manner as advertised. So that's why you got to wait a while. But I'll try to reword it to make.
Thank you.
That
Thank
makes
you.
sense. I would ask the city manager, Robin, if you're tuned in at all. I mean, that to me is a little bit more operational, so I would want the opinion of the city manager. Does that align with,
Does that work for you?
yeah, does that work for you? And I can brief you on where we were.
Are you saying the 90 days?
So the concept of you have to choose from the applicant pool, if not, you have to wait 60 days to re-advertise.
So if you have a position come open for
Yeah,
something.
we-
you've
I don't
already-
think we've ever done that, but
That's
I
okay
wouldn't be
with
able to tell you that.
Would you be okay with it? Does
That's,
it,
I mean, if that's what we have to do, it doesn't make much sense to have to wait 60 days, but I
Well,
don't think
should
it
we
makes,
shorten that period? I mean, it does.
it doesn't
sound-
make much of a difference. You can, I mean, companies typically want to re-advertise as soon as possible. You don't want to leave a position vacant.
you're not understanding. The first 60 days, say that position becomes vacant, another one, you can pull from the candidates that were qualified already. You don't have to re-advertise within the first 60 days.
Right. No,
You
that's
can pull
fine.
from your already interviewed candidates.
That's fine.
That's okay? All right. I said that correctly, right?
Yeah.
Yes.
Okay. All right. Can I move on? Number 6, employees chosen for interview for the city jobs will be allowed to interview during work hours if necessary. Departments shall work with the employee to make reasonable adjustment to the employee's schedule to permit the interview. If the interview takes place during the employee's scheduled work hours, the time will not be paid, and employees should use vacation leave for such purposes. All other interviews are unpaid. I disagree with this. If you're actually trying to fill a position that's within the city and we're trying to promote people to move forward, they should be paid for their time if it's during work hours. They should not be required to take vacation time to do an interview within the city. Outside of the city, I hope they don't do that, but we can't pay them for outside of the city. But in the city, it should be covered.
Sounds reasonable to me. It's an hour or two, and
You guys okay with that?
I agree.
Yeah.
And-
So we strike, if the interview takes place during the employee's scheduled work hours, the time will not be paid, and employees should use available vacation purposes. All other interviews are unpaid. Strike those last two sentences. Is that what we agree on? Well, actually, all other interviews, I don't know if I want to remove that, because if it's an other interview like it's not within the city, you don't want to pay them. Does that make sense?
yeah, we're not paying for other people's interviews, but if it's for the city, then
So,
we don't need to take PTO.
I don't think you're reading the last sentence the right way. It
That's-
doesn't have to do with non-employee applicants. What it has to do with
Oh,
is
if
when
it's
does the
5 p.m.
when does the interview take place?
So is there a legal reason to have somebody take PTO
Well,
for?
so
if it's after work hours, it shouldn't be paid.
why I have this is because we have to think about what is compensable work. And it is not compensable work to be interviewing for a job that is not the job that you currently have. And so then if you get in a situation where, okay, we're going to pay you for interviewing for another job, then if that's compensable, why isn't it compensable? Why does it stop being compensable if the interview occurs at 6 p.m. after the office is closed for business? So it gets into an administrative nightmare. It's totally up to you to recommend whatever you want to recommend, but, you know, that the argument is the taxpayers are paying those people to do the jobs they currently do, and it's great and aspirational that, you know, we want our employees to advance and look for things they may want to do alternatively, but paying them their time to do that is awfully generous.
Do you think it matters if they're hourly employees on a clock versus salaried employees? Like, in
Well,
my
so-
opinion, like salaried employees, like, maybe they just work an hour later because at 3 o'clock they did the interview, but they're not going to cheat the city out of the hours. They're going to just
Well,
work
that's
later.
correct. And
Versus
the other
like,
issue, of course, is that salaried employees are under FLSA. If a salaried employee works even 1 hour during the pay period, they must receive their entire salary. The only reason they cannot be paid is if they do not work any time during the pay period. And so it really doesn't matter, you know, with them. But you're right, I mean, because I don't want to say salary, but FLSA exempt employees are usually managerial, executive professionals, and they just have to get the job done. And if they go and interview for city manager or whatever, you know, if they're, let's say they're a department head and we're interviewing for city manager, then yeah, they're just going to have to go back, you know, to their department and work till 7:30 or whatever to get that day's work done. So this really deals with hourly, you know, employees and how they're going to be.
so if it's hourly employees, couldn't they just like clock in and clock out as opposed to having language that they have to take vacation time? They could just like punch out?
Well, the issue of
Do-
vacation time is if they wish to be compensated. So if your policy is interview time is not compensated, but I want to get my 40 hours, this lets them use their vacation time for that hour or whatever that they're interviewing.
I think honestly, if we're trying to promote people within, they deserve to be paid for the interview time. However, if it's after hours, they don't deserve to be paid for it. That, if it's after hours, I mean, that's what we should work for, is interview them outside of the work time. But if it has to be during work time, I think they should be paid. Because the reality is if they were salaried, they're going to get paid. It's like you're differentiating at that point. I don't know, it's up to you guys too, though. I have my opinion. What are yours?
Like an hour for an interview to try to develop our professional staff is, it's not like a huge time that they're like away from the office for so long. Like, it seems like a good investment in our human resources to try to promote from within and develop our talent. And
Yeah.
I feel like as far as like the taxpayers, we have an interest in having a really well-qualified workforce is like the overarching goal that city needs are met. So I feel like I'm agreeing that it seems like a lot to say. I mean, I understand the point of, are they working during that particular hour, but I don't think we're talking about that many hours and that many
Like
people.
2 hours, maybe $20 an hour to $40 an hour. I would say it's not a large expense. I would almost encourage us to do them during the work hours because that's when HR is there anyway, right? So and you're already going through the expense of paying the other two interviewees during our work time. So I would think I would encourage us to do them during the work day and pay people for it.
So how about the replacement third sentence is, employees who interview during work hours shall receive their normal pay?
Yes, excellent.
Well,
And
with that.
city manager, does that
Okay with
sound
that?
reasonable to you? Okay, and I actually want to revisit
That's
5.
fine.
I am doing a lot of recruiting right now, and it is not easy. And the idea of delaying it by 60 days, I'm a little troubled by that. I actually would want to sleep on that one, or if I don't know that I have a formulated opinion, I just know that I don't know that delaying reopening a position 60 days is ideal for operations. Other thoughts and comments, city manager or attorney? I'm not comfortable with 5 as it stands.
I mean, you want it reopened within 60 days, or you're like, let's pull from that pool that's already been interviewed?
I think the way it's written currently is prohibitive to operations. I don't know the correct way to state it, but I don't know that saying that you have to wait 60 days to reopen. If I'm understanding correctly, it's saying you have to wait at least 60 days to reopen a posting if you aren't happy with the candidates, and 60 days is a long time.
No, I didn't understand it to be that way, if that's what it was.
Am I
Is that what it's
misunderstanding?
reading?
No.
Okay.
Can you let me reword it before we?
Sure,
'cause
okay.
We're spending a lot of time,
Okay.
we have a lot of pages to get through.
All right.
So since I'm going to bring back a reword.
Sure,
we
yeah.
can-
Sounds great. All right.
That's,
You guys ready for 7?
Yep.
All right. The Human Resources staff may establish eligibility registers for positions as required turnover frequency or other recruitment issues. Positions that are identified by department or Human Resources Department as being vacant on a regular basis or having certain recruitment needs may have an eligibility register for qualified applicants established. The Human Resources staff is responsible for establishing the registers in accordance with the city policy of non-discrimination. I don't understand I think it's the right idea, but I don't understand what an eligibility register is. Is this where you track possible candidates that you solicit to come in, or what does that mean?
It's for positions that constantly turn over, like rec aid. And so we just want to put a list together that says, if you're on this list, doesn't matter when you applied, you're eligible for it, we can reach out and offer you the position.
In other words, it may not necessarily expire.
That is, it's an
Okay.
eligibility register. You're just on it because these positions turn over all the time. Solid waste collector, driver, another one that's always turning over. That's what this would be used for. It makes it more efficient because you don't have to say, well, you didn't fill out a new application. Your old application is stale. You're just eligible.
okay. And on all of these things that are more operational in nature, I'd like the city manager's input, because to me, we're heading into, it's part legal, part operations.
And I would just say, that, so we have a HR staff person.
Which
she's
is
not-
currently the city manager, because Megan's not here, right?
Yeah. So my assumption is, and the manager can correct me if I'm wrong, is that between he and Megan, they've already read this, or and we would hear if they have a problem. I mean, I think
That's
it's.
correct.
That is
Yeah.
correct? Okay, that's what I want to know, because, again, it's operational in nature.
You guys okay? Number 8? Okay. No employee may begin activities associated with working for the city, including engaging in post-offer screening activities, until the candidate signs, electronically or otherwise, a conditional offer of employment. No term of conditional employment, including matters of pay, bonuses, expense reimbursement, or other similar matters, shall be effective unless included within the conditional offer of employment. Will these be automated on the payroll system or the human resources system, Mr. Gomez?
Yeah, yes.
Okay. You guys good? Okay. 9, the city manager and human resources staff are authorized to adopt such forms and procedures as are deemed necessary to effectively implement these employment policies and to conduct such pre-employment screenings as may be either legally or administratively required, including background and reference checks and physical and psychological examinations related to job functions. For any position requiring a pre-employment post-offer examination, it shall be job-related and given uniformly to all candidates conditionally offered the position. Candidates must meet, satisfy any established screening requirements, and any candidate who fails to do so may be denied employment. In addition to the foregoing, for any city position requiring interaction with law enforcement personnel, records, or other matters, access to security facilities, or otherwise required to pass background standards promulgated by a regulating agency with jurisdiction over such records, personnel, or facilities, employees holding such positions must be able to pass the relevant standards, and their inability to do so will disqualify them from continued employment. Is this like getting into the certifications and stuff we've already discussed? Where if you have a license, specific type of license to do a job?
Well, so, I mean, there's a variety of things that are addressed in paragraph 9. Obviously, it's the logistical things that allow the manager to do whatever forms and procedures that he needs. But with respect to the meeting the requirements of outside agencies, so for instance, I think the city does after-school care or something like that. And so there are regulations where, in addition to the city's requirements, the state has requirements for who can interact with minor children and so forth. And what this really says is, you just because you passed our stuff, if we go and do your, if you need other stuff, a certification from whatever, building official needs his or her state certification, that you've got to have all those things before you actually can work, and if you don't, you're not entitled to work. It just really makes it crystal clear, so there's never any argument that, well, gee whiz, you gave me this job, you hired me, and now you're firing me. We've got something to point to say, no. I mean, if there was more elements that were needed and you couldn't get those elements, then you're dehired.
And since if it comes back and somebody was to say that, okay, you didn't state this inside of the offer, and it could come back to where we'd have to look at this at potentially any type of an appeal, would it be reasonable to ask that the Civil Service Commission at least be able to look at those forms before, so that way we can look for document control, making sure that the revisions are standardized, things of
Yeah,
that sort?
well, I think you guys I talked before about looking at every single form that the city uses.
Is that covered explicitly in a different area that would cover any type of form that we need to look at? Or does it need to be stated in here?
I don't think it's the personnel policy. I think you all talked about when you're done finished with this project, that the very next project you turn your attention to would be the city's various administrative procedures and forms.
That's why I'm getting on this one. Could we see these forms before they're implemented?
That's an
Can we do that?
administration question, but.
I don't want to control what he's doing. He's doing a great job. He needs to be able to do that. But if we have to look at a form, if we have to know that, hey, this could happen, I would like to at least be able to see what does the form look like before it's implemented, and make sure we have document control. The problem is I've seen some forms when I've done record requests, there's clearly not a document control. So
Do you mean like the offer letter? Wouldn't
No,
this-
no, no, no.
This would be in the offer letter, right? Like, you need to have X, Y, and Z.
The standard form that they would use. The offer information they put inside of it is the information they put inside of it to make the offer. But what does that form look like? So that way, if we have to come back and ever do an appeal based on that form, we've at least seen it and we understand what the contents are in that form.
But
So
that is
you're
in the
to
offer
implement-
letter.
Say what?
It is in the offer letter.
It isn't, that form, though.
So I guess.
There is no form, it is just an offer letter
Just an
stating that you need such certification. I'm not following why you would need a form, just to say that you need to have a certification as a professional engineer.
I think
It says here, the line for
it's
any.
allowing to have the ability to include whatever you want to make sure that people have the job, are able to do the job. That's how I'm interpreting.
We just want to know what the basic
Well,
form
but it's
looks like.
listed in the job announcement for one, what is required,
Okay,
Yeah.
right.
and then
City
usually,
admi- So I guess it says that you are able to adopt forms and procedures to implement policies. I mean, it's allowing him to do that. It's not saying they exist.
Yeah. But it's also, if you go down, it says, for any position requiring a pre-employment, post-offer examination, it shall be job-related and given uniformly to all candidates conditionally offered the position. So there's things in here that should be consistent in every single form, if that's the case, if it's for
You're
that
trying-
specific job.
You're saying that you want to implement something in this. Let's think
The
about that.
form needs to be standardized. If it's an offer letter, it should be a standard offer letter. It doesn't mean he has to put specific content in it, because you know what you need to offer for a position. We don't know that, and we should not control it. But we should know what the form looks like, so that way if it ever comes back and somebody says, I was offered this, and they do an appeal, then we know what we're looking at. Because if, otherwise, we're saying, hey, here you go, free reign, but we don't know what the form is. We have no idea what it,
Well,
what
first
we're
of all,
looking at.
that you don't hear an appeal for not getting a job.
Okay,
So that, it would never be before you in that context. But I think what the manager is trying to say is, we have an offer letter, and in that offer letter somewhere is wording to the effect of, if you need other stuff, you know, a license or a certification or whatnot, you still have to get that. So just because this offer letter is being given to you, it's still conditional upon your satisfying. I believe that's what Manager Gomez, am I getting that correct?
that is correct.
All right, so
could we see the blank generic form? That's all I want to see.
We don't, we have a letter, I'll email you copies of offer letters that we've issued.
Okay,
That's what we currently have, and that's what we will be using, our offer letters. I'm not aware what else we would be able to legally provide somebody that we're offering a job, other than a letter conditional on what's listed in the letter. If you need a certification, you need to take an exam, if it's requiring a physical, whatever that is in the offer letter. And that is the only form that we currently use.
okay. With standardized document control, I really think it's important, I think personally it's important that we at least see the blank document. The content of what they offer, which is going to follow what the pay scales are, it would follow what the job description is and the requirements of the job description. That's their job. But if we're saying, and I'm looking at this, if I'm looking at it right, they're authorized to adopt such forms and procedures as are deemed necessary to effectively implement these employment policies, to conduct such pre-employment screenings as either may be legally or administratively required, including background reference checks and physical, all that. And we're specifically talking about the employee policies and procedures. We need to at least see what's
I
going on.
guess I would say.
I don't want to know,
Yeah.
what did you offer them?
But,
So-
I
okay,
want to
so-
see the document.
But there could be so many different kinds of forms that are used. Like, I'm thinking, when at Manatee County, when they hired, I don't know if they do it in this building department, but when they hired building inspectors and plans examiners, they had developed a form that they use that asks that person to demonstrate their knowledge of, you know, here are photographs of 20 different elements of a building. Can you tell me the correct word of that? Is it a lintel? Is it a footer? You know, is it a truss? As you could tell, I used to work in construction. And, you know, but that could be so different in so many different departments. You know, the fire department has stuff it uses for firefighters. You know, I don't know that there is a standard form that is what you may have in your head.
So there's not a standard form.
So I guess as long as it's being, I guess, to me, I have no issue with this clause, or bullet, whatever, it allows the ability to use a form, but to be clear, it says in here that it has to be used on all candidates, right? Does that,
Right, like when I do management training, I use the example of, okay, if it's a job that requires physicality and you want people to demonstrate that they can run up the hill and
Yeah.
run down the hill, and you've got 5 fellows lined up in front of you,
you have to
but
do it
because
all.
one of them is a strapping 20-year-old, you can't say, I already know you could do it, you don't have to do it, but these other old guys do. If we're going to make somebody do something, be it
They'll have to do it.
physical, mental, typing speed, whatever, every candidate has to have that same thing applied to them. That's all what that means.
So I think you're getting more into wanting to review the actual forms, but I think what the policy is doing is establishing what's possible, and what it says in the policy is you have to do the same for everybody, but you're able to use other tools to establish whether or not somebody's competent and capable of doing the
Well,
job.
and the manager is going to send some examples of offer letters that they do. I've honestly must confess, I've never seen one, so I don't know what the city of Madeira Beach uses. I do know that for other clients, I've developed a standard offer of employment form that says various things that I would like every single offer to say, including some of the stuff about
Right.
just because we're making you this offer doesn't mean, blah, 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 and you understand that your employment will be controlled by the personnel policy, and benefits may change from time to time, and so on and so forth. I don't know if there is such a standard offer letter here. I know some employers just say, hey, we'd like to offer you the job, and and like just last week, I dealt with another client here in Pinellas that did an offer letter and set forth benefits. And so I called that manager and said, hey, you don't want to be doing that in the offer letter because benefits change over time. If the insurance gets too expensive or coverage needs to change, and if you put it in the offer letter, they have an argument that they're entitled to that for their entire career. So there are standardization things, but let's see what the manager gives us, and
Okay.
if y'all feel that some more standard offer letter should be developed, we could do it at that time.
So we need to come back to this, is
Yeah,
what we're
Clara,
saying.
may I request, are you the keeper of this list on the future meetings list?
Yes.
May I add review of offer letter and document control as 2 separate items? And then Jerry, would that suffice?
Yeah,
Because
this
I think
is-
you're extending beyond the policy needs, but you've identified something important, but are you okay with that?
I'm fine with that.
Okay.
I'd like to, once we get that, I'd like to look at it and then readdress this if it needs to be readdressed.
Okay, we'll
Which I think we
reconsider.
could just bring back up in another meeting, right?
Yeah,
As
we'll do a
necessary.
final clean through
Yeah.
of the policy, I would
Yes, that's
believe.
correct.
So,
Yeah.
Yes,
You'll
so,
see us
okay.
strike through, underline, and we'll.
You guys
And
have
on
any
any of
cons-
these items, it's a rolling list.
Yes,
You
ma'am.
can pick certain ones to talk about next or whatever at another meeting.
Excellent,
Do either of you have any,
Additional
is it okay to
comments?
move forward?
okay.
You okay to
Very
move
good,
forward?
yes, sir.
And then for number 10, I don't know if you want to just skip it for now, because this ties into the discussion y'all are going to have with the commission.
Skip
So-
number 10.
So you guys are aware, with just real quick, a brief review, we're trying to identify what at-will and what was it called, at-will and serving at will, what positions are they? If every person has to go through a dismissal for cause, or if the city manager can dismiss at-will people for any cause, no cause, or for cause. And that's, we had a discussion in the last meeting, which you guys can go back and look at that on video.
I
And
was-
trying to
yeah.
identify what is it we would like to have happen.
Okay.
We are going to bring this up on the 25th. We didn't take a vote on it, right? On this one, we took a vote on the other issue,
You took a vote on what's going to be listed on the joint meeting.
on the joint meeting. And
Yes,
this
sir.
was one of those issues, to talk about what at-will employees are, or if every employee has to go through a specific process to be released from employment.
Well, it's, see, if department directors will have the opportunity to go before the Civil Service Commission,
That's what we discussed, yes.
and about the more teeth or whatever in the charter, changing the charter.
Yeah,
Yes.
there's 2 issues. One is, is the Civil Service Commission going to become an actual adjudicatory body that can overturn a dismissal? And then number 2 is this issue of what level below the manager, if any, will occur?
Okay, that, I'm clear on that. Judith Ann, do you have any questions? No? Paul, you were there for all of them, so, okay, we'll skip 10 and revisit. Continuing to 11,
I'm writing down a note real quick, sorry. Okay.
take your time.
All right, 11, all volunteers are not city employees for any purpose. However, pursuant to Florida statutes 440.02, provides eligibility for certain worker compensation benefits for municipal volunteers. Therefore, city volunteers must comply with all related city accident or injury reporting procedures.
Fine by me.
No concerns. You guys okay?
Well, except for grammar purposes, I just caught myself. Pursuant to should be taken out.
I don't even see it now. Where's pursuant to? Okay, all right. Pursuant to, okay, got it. Okay, employment of persons under 18 years of age in either regular or temporary positions shall be subject to and in accordance with applicable child labor laws.
Fine
No
by me.
concerns.
No.
You guys good? 13, to ensure compliance with the Affordable Care Act, when an employee formerly eligible for health care benefits leaves the city's employ for any reason, he or she shall be ineligible for rehire until the former employer has been separated from the city for a minimum of 13 weeks. That's federal law, right?
Yes, that's what everybody calls Obamacare.
Okay. Are you guys?
I don't agree with that. No, I'm
You
just
don't agree with
kidding.
it either? Okay, it's federal law.
Yeah.
It's not a thing we can choose.
just
Okay. Next page, item B, temporary employment. 1, temporary employment for purposes of this policy shall include, A, OPS regular, other personnel services, positions, including non-student interns, which cannot extend beyond 6 consecutive calendar months. Concerns? Nope. B, OPS on call where employees are called unexpectedly on as needed basis to complete a specific task or assignment. Other personnel services, okay. That does not mean regular employees that are full-time and normally engaged with the city,
No, so
correct?
these are people like, that if the city were to do periodic beach cleanups, for instance, I'm just making something up, we don't know how frequently we do that. All we know is that we have a small subset of maybe semi-retired people or whatever who like doing that, and they just sign up for it, and then whenever we need them to do that task, it could be 4 times a year, 6 times a year, who knows, we call them in. That's what that category is for.
Understood. Everybody okay?
I just have a question about the OPS. Is there a reason why they can't be more than 6 months or extended beyond 6 months if the city needs it?
I think it's a situation where you try to make a clear, the legal answer is no. I guess, practical administrative answer is that you try to have some separation point there because you don't want the employee to argue, I've been here 17 years, why am I not at least a part-time employee? Why am I still down at OPS? So it's just a line that is drawn. If you don't like it, you can take it out, but that's a.
Makes sense to me. When do they become,
makes
why
sense.
aren't they a full-time employee at that point if they're working with us?
I've had to hire OPS people when we had insecure budget projections and maybe not the ability to hire a permanent person, but had a need that we could fill with OPS.
Why couldn't
and-
you do part-time?
Well, because once you're part-time, then other things are
different type-
triggered.
part-time is a
and it's
different
like,
type of
then they're
position.
like a permanent employee and you can't like hire, fire for the, you get constrained once you have like a regular position that you're filling versus an OPS allows you to fill a need without like a long-term commitment or a long-term budget projection that you've got X thousands of dollars that like ad infinitum, you're going to be able to continue to rehire this person. So, I mean, I can see where with, like, by and large, it's not ideal to operate on your organization with temporary employees, but I've been somebody who has had to do that for extended periods of time. So I don't know, it just seems like,
Limiting?
So OPS is not intended to be operational needs, correct? It's just when you, like you said, if there's some unusual summer event or.
Sporadic, unexpected, work overflow, all of those kind of things. I think part of it is the expectation of the applicant, like it's good for the employer to say, here's your job description, and it says OPS maintenance or whatever, OPS custodian, so everybody knows going in, you're not going to be here on a regular basis, even if it's part-time. I think when an employee, an applicant comes in and says, I'm applying for part-time employment, that employee is thinking, for a long time, I'm not working full-time, but I'm going to get 20 hours from this employer for years, hopefully. Whereas an OPS person comes in knowing, I don't know if I'm going to be here for a week, 3 weeks, or 6 months, but I know this isn't going to be any long-going gig, if you will. So that's why I've created these categories over time. You don't have to, like them. I just think it actually gives a good option for the employer to delineate. And also, on the employer side, when you have benefits of different types, like for instance, vacation accumulation, sick leave accumulation, healthcare coverage, you may make choices of full-time employees get this, part-time employees get this, but then you may not want to give anything to OPS people. But if you call them all part-time, then arguably you got to sign them up for insurance or whatever benefit you're giving to your part-timers. So it creates that third tier of, I don't want to say expendable, but
No, I know
very,
exactly what
very
you mean.
short-term people. It's almost like employee leasing, but bringing them on our books.
I guess I would just feel more comfortable. I mean, that's an ideal scenario, but it just seems like it says cannot extend. Like there just might be a circumstance where the city manager
And
or
why
the
don't you
staff
say,
might want to extend.
Which usually does not extend.
Yes, that sounds good, which typically doesn't extend.
All right.
Is that on the item A, is that what you're talking about there? Does not
Yes.
extend, okay.
Typically does not.
Okay. May we move on to C? Everybody okay with that? Okay. OPS seasonal positions where employees work a seasonal assignment, such as summer camp or pool guard. No issues? Okay. OPS intern positions follow guidelines provided in section IB3 of this policy. B3. So we have to read that whole section to know, okay. Interns are considered as OPS, is that what this intends here?
I'm sorry, you're talking about
This-
D?
Yeah, D. Does that mean that interns are an OPS employee or just some other form of temporary employment?
Correct. But there's, the Labor Department has cracked down in the past 10 years very seriously on what people call interns. A lot of employers bring them in and really just use them as slave labor, so to speak. And so the Labor Department has adopted these standards, and so when you get down to 3 and it says interns, these are what the federal government, that the Labor Department will need to see if the city ever brings in an intern and calls them an intern, that this person's going to be doing.
Okay,
So when you get to 3 there, you'll see what all that's about.
understood. Everybody else okay? Okay. All right, E. Other temporary employment programs not specifically defined herein shall be considered as the option of human resources staff in compliance with the federal, state, or local laws, rules, or regulations governing such programs.
I'm ready.
Issues? Okay. 2, unless waived by human resources staff, employment procedures described in section IA of the policy shall apply to employees hired in temporary positions with the exception of temporary employees defined in section IB 1DE. What the heck? Okay, of this policy. What is IB 1?
So basically, it's saying whether we're hiring full-time people or part-time people, we want that process to be used where they apply and so forth, but except for the temporary employment, which is the B1, D, and E.
D and E, okay. Why would human resources waive that?
Well, you would waive D because interns are like, somebody from USF knocks on your door and says, I'd like to be I have a interest in a career in the future in government work and I'd like to be an intern here. So you're not going to have them, fill out an application or whatever. You're just going to say, we'd love to make you an intern. Show me your resume. So that's why you,
So if it's waived by Human Resources, does that mean they have to fill out an application? I don't understand why that's put there. That confuses me. Am I
So-
reading it wrong?
Policy shall avoid exception. So it's saying all except for G and E have to do the
Right.
regular stuff.
unless waived by Human Resources. So D and E don't have to, period.
I would put unless waived at the end. Maybe that'll make, so read it that way. Employment procedures described in whatever must be done by everybody unless waived.
Okey-doke.
Section 1B, 1D and E. Okay, understood. That would make sense. Are you guys okay with that? Just the way it looks like they don't
Yeah,
have to
you
do
read
it.
unless waived, yeah, it was,
Yeah.
yeah. Yeah, everybody has to follow it except for the interns unless HR says so.
Yep.
Yep. You guys okay with that? Yes. Okay. Number 3, interns. A, the city provides internship opportunities for students to experience work in the city government that is relevant to their educational goals and objectives or personal career interest, and to non-students seeking to experience working in a city position. Agree.
Yeah.
You guys okay with that? Okay. B, recruitment of all interns shall be conducted through the city's regular recruiting procedures outlined in this section unless otherwise approved by Human Resources staff. Why?
Yeah, that's confusing because we said they're not doing regular stuff. So, I mean, is it shall be done by,
Just drop B.
yeah.
Just
okay.
drop the entire B?
Mhm.
Okay. C, interns shall be recruited to fill regularly authorized position vacancies or displace, shall not, I read that wrong. Interns shall not be recruited to fill regularly authorized position vacancies or displace regular employees. Interns are considered temporary employees and are not eligible for benefits provided regular employees. Intern appointments shall not exceed 12 months. Should we stick to 6 months like that is, or is 12
This
months
is part of the
necessary?
Labor Department.
So
This-
that is something that has to be
Yes.
there, okay. All right. D, Delta. In order for a student to be eligible for employment as an intern, an individual must be a student in good standing, enrolled in or on school-approved break from an accredited secondary or post-secondary school, junior college, college or university, or vocational technical school. Good?
Okay,
E, student interns are required to notify the employing department of any change in their academic or disciplinary standing at the institution.
okay.
F, interns will be paid at the minimum pay rate of assigned pay grades. A departure from the minimum pay rate may be approved by Human Resources staff upon request and proper justification from the relevant director. I'm
Sounds fine to me.
concerned about that.
You are?
Yeah, what?
Interns
Why,
will be
what,
paid.
I'm sure the limits have to be within whatever that position is, but if they're interns, why would we pay them more than the minimum pay rate?
They
Because
came back for
the
a second year.
person who is
or-
interning is currently ranked #1 in her class at Harvard for chemistry, and we're desperately in need of a new lab chemist director. I mean, no, that's
It makes
seriously.
Or they
sense,
come
it makes
back and-
sense, I get it, I
Or
understand.
they come back a second year. I mean, you
That's-
want to
yeah.
raise their pay. They came back for.
There are a variety of
yeah.
reasons, but
Yeah.
usually it surrounds, we'd really like this person to come work here when they graduate.
That makes sense.
So-
All right. You guys good? All right. G, persons who may be students but who wish to volunteer for the city outside of any academic program must complete a volunteer service agreement to be developed by Human Resources with assistance from the city attorney as needed. Okay. H, students who are present in the workplace and who are not performing any services for the city nor participating in any related academic program are considered to be job shadowing are not considered to be volunteers or employees of the city. Any persons who job shadowing must be approved by the relevant department director in advance, must not perform any work for the city, and must be under the direct supervision of an employee mentor.
And will not receive pay. Does that have to be in there?
Does that
Or is
need to be in there? Or is that the way it's written is good for that? And will not receive pay.
We will
Would
not
not be
pay you.
compensated.
Yeah. I'm just making sure. We're not paying you.
Yeah.
Well, it
Yeah.
says that they're not considered employees of the city.
So that would indicate that, okay. Everybody good?
Yeah.
I think that's a good question.
Just making sure.
Students who are present in the workplace and who may perform work for the city but who are not compensated shall meet the requirements of the Federal Department of Labor concerning the acceptance of work for student interns.
Okay.
Interns who are not students must be compensated at least the prevailing minimum wage for work performed for the city. J, the Human Resources Department is responsible for the development, coordination, and promotion of intern recruitment activities and is responsible for ensuring that all interested persons have an equal opportunity to apply and be considered for internship opportunities. K, notwithstanding the foregoing, Madeira Beach may, from time to time, enter into agreements with educational institutions whereby student interns will be identified, assigned, and compensated pursuant to the terms of such agreements. In such cases, Human Resources shall assist hiring departments as needed to implement the terms of the agreements, even where same may vary from the provisions of this policy.
Missing in
I
the
totally
last
agree
one.
with that, because we have a summer career celebration program within Pinellas County Schools, and I would love to see those kids working for the city.
Yeah.
That's just me personally.
Well, and like USF runs programs, but USF insists you follow their stuff. And so what this says is if that's the case and we agree to partner with USF, if they want something other than what these policies are, we'll do what they want.
Everybody
I think you
good?
needed the, right? Even where the same may vary from, I just look at that last part. God.
You okay?
Yeah,
You guys okay?
we might be missing a word.
4, employment of temporary personnel shall be subject to the equal employment opportunity provisions of this policy. 5, to ensure compliance with the Federal Affordable Care Act, except for seasonal OPS staff, all persons employed in temporary OPS positions who are not offered health care coverage shall not be scheduled or permitted to work more than 27 hours per week. I guess that's a federal one, is that right?
The Obamacare says that if you let someone work longer than that, you must offer them health care. So this is just telling management, do not schedule them more than 27 hours.
Is that 27 on average over a period of time, or is it 27 period?
27 period.
Period, wow, okay.
Why
All right.
are the seasonals allowed to?
Why are the seasonals allowed to?
Except for seasonal OPS staff.
Well, because those are OPS. And Obamacare only deals with
think it's 29.
employees, full-time and
No, we can
part-time
let-
employees.
We can let our high school students work up to 40, but that's a
So
different.
Obamacare, the Affordable Care Act makes an exception for seasonal employees. They aren't ever going to be offered health care, no matter how many hours they work.
Okay, okay.
It's like the folks, the agricultural industry who uses migrant farm
Okay.
workers lobbied for
Okay,
that.
understood, thank you.
There was a question presented on the 27 hours. Can we verify that's not a typo and it's not 29?
Sure.
Sounds like you have reason to know.
If you work at least 30 hours, you're considered full-time. So I think that's why we use 29.
No, employers just do that as a trigger for who's full-time and who's part-time. But I'm fairly certain 27 is the trigger, but I'll look it up and make sure that.
Thank you. Everybody okay? 6, unless otherwise required by law, individuals performing work for the city through a temporary employment agency shall not be considered employees for purposes of this policy.
Okay.
Ooh, we are getting there. Okay.
So can we just, I want to make sure, is there anything we need to talk about? I mean, we're at an hour. I think we're going another hour, right?
No, we can go 24 minutes. I think we're
Okay.
scheduled till 5. Is that right?
Okay.
Yeah.
So how much is left in the packet?
A lot.
Okay. What is, we're doing great, team. Is there anything we need to tend to today before we continue to proceed? I'll stop us, so we have 24 minutes. I'll stop us 5 minutes before so we can kind of wrap. So everyone keep, in 20 minutes, we need to stop. So anything we want to talk about before the next meeting with the joint meeting?
Could we bring up, just so we're all in understanding of what we would like to voice in our opinions, when we go into the 25th and we've asked for that joint meeting, are you okay if I just go
Yes,
ahead?
yes, sir.
Okay.
So we'll talk about this and then we'll return with any remaining time and then let's stop 5 minutes prior.
There
try to
are
close there.
2 items. One is, what is our ability to overturn a decision to dismiss an employee, and when and what conditions? I did provide Clara with some information. I can't send it to you guys. I think maybe she can. But I found some wording, and hopefully she sent it to you as well, Mr. Eschenfelder. Huh? I sent that a while back, where I was concerned, because if it comes down to, we have an appeal, and that appeal means, and we find that a person was dismissed for not an adequate reason, then if we say the person should be rehired, if the Board of Commissioners agrees with it, the Civil Service Commission has no other authority other than to reinstate the person, and then the city manager has to do that within 5, 10 days, whatever the case is. But we can't give back pay, we can't force him to do a different punishment, we can't prevent him from doing a different punishment. We can only say that that employee should be reinstated because it was an incorrect dismissal. That's the only opportunity we would have. And that's, I don't know if anybody wants to go any further than that with it, but I did send some wording to Clara regarding that.
I'll look it up.
Huh?
If it's been a while back, I'll.
It's been a while back. I can,
Jerry, I mean, we're entitled to have a hearing. The employee aggrieved would have a hearing before us. How would all that take place?
it's the normal appeal process, which would be, is that quasi judicial? What is that called?
Correct. Quasi judicial, yeah.
Yeah.
The testimony's under oath.
But in the past, we've run into a situation where the Civil Service Commission has requested the presence of the city manager, and he just didn't show. And the word.
Again, we talked about that
the word
already. You have
came
subpoena
down.
power, so you could
Right.
subpoena him, and if
But
he does,
it came down that the manager it was recommended to him by the attorney that he just not appear. I
So
mean,
help me
we're
understand.
up against it.
You're saying we talked about that, help me understand, so you're saying we have subpoena power, so and how would that have been better rectified?
We
He didn't
could,
show up, there's nothing you
if
can do?
the Civil Service Commission felt that it could not make, at that time, a recommendation on the case without the testimony of the manager, and the manager refused at the request and invitation of the Civil Service Commission to come, then the Civil Service Commission would instruct me to issue a subpoena. I mean, you would vote to issue it, I would actually type it up and get the chair to sign it, and then we would hand it to friendly local law enforcement, who would go and administer it. And that might require you to adjourn and come back at another day when the manager would be present, but I've got to believe that if it ever came to that point, that the manager would come out of his or her office,
Sure.
not wishing to interact with friendly local law enforcement and come to the podium and answer your questions. But who knows?
So that power currently exists
Mm-hmm.
the way the, okay, so you could have, Paul, it sounds like, issued a subpoena previously, you just
sounds
had
like the
not.
person was told not to show by a different lawyer though, right?
Yes.
Yeah.
Okay, so it
Well,
sounds,
other than the employment lawyer or by the city attorney.
Interesting.
Yeah, so in the work, what I do, I can't speak for the prior law firm that did your labor and employment, but a civil service commission, civil service board, whatever they are called, if they have that quasi judicial power, then I am your legal advisor.
Okay.
And a different attorney will assist the administration in prosecuting the case, putting on why management showed just cause, cross-examining the employee and any of the employee's witnesses. That's how that would go down. There's a Florida Supreme Court case called Cherry versus Deason, which says that in the case dealt with the Florida Public Service Commission, and so you had the lawyer that was the Public Service Commission's attorney, and then he got up and went to the podium and prosecuted a case before that very same board, and then came back up to the podium and told the board what the law was. And so the Florida Supreme Court said, two different lawyers from the same law firm can do that, or the same in-house office, but the same lawyer can't be both prosecutor and advisor. So if you ever do get the quasi-judicial power, and of course we have to talk to the commission about that, and we have a case, I will be your legal advisor, and one of my colleagues will, if the administration desires to even have somebody, but usually, they do, especially if there's a lawyer on the other side. And so that colleague would be the prosecutor and would, again, present the management's case and cross-examine the employee and his or her witnesses.
How about a situation where the employee would be terminated without having, say, progressive discipline?
Well, that's all, so that would just be part of the appeal to you. That, in other words, you would get an appeal from an employee who said, I was terminated, I feel I shouldn't have been terminated because, and then it's up to them to put on a case why, because, and part of that could be, I didn't get the progressive discipline. And then management puts on its case, and management would say, well, we did give progressive discipline, and here's how. Or management could say, well, under our personnel policy, and we haven't gotten to discipline section yet, there are certain things that an employee can do that are so bad that are terminable on a first offense. And so we did not have to give progressive discipline. So who knows how the argument would go.
Right.
But that would all be part of what you all hear during the appeal hearing to decide who wins.
Right. So I definitely hope we, achieve at least having the ability to hear these cases as they would arise, which hopefully would be rare or never. But I know that, I don't know how we're going to go about presenting this to the commission in a way of, getting them to see our side of this, but it's up to Jerry, I guess.
Am I allowed?
And
Am I allowed to read the things that and I don't think you've even seen this yet, because I was assuming that it would go through Claire to get to you, so I apologize for that. That was my mistake. But I found some wording that is, I know it's legally written, and it minimizes what we're allowed to do, because I don't think we should ever interfere with the city manager doing day-to-day operations. That shouldn't happen. Just the inability, from the things I've looked at, what's been said in the past Board of Commissioner meetings, we should have that ability to only overturn a ruling if it's made, or overturn a decision to dismiss an employee if it's been an incorrect process of dismissing a person. There's things where I've seen that it talks about, can we look at other disciplinary processes? So like if somebody's disciplined and they're actually suspended for more than 10 days without pay, can they appeal that? That's a decision that we have to talk about too. So it's, in other words, if there is a decision to punish a person, and personally I don't think suspending a person is ever effective, but if that's the case and a person is suspended, they really shouldn't go more than 2 weeks without pay. I mean, what do we want to look at there? What do we want to ask the civil service, or the Board of Commissioners, what is it you'd like us to look at?
yeah, what is our plan? What is
That's what
our
we have to
agenda?
identify. The agenda is to say, and let me see if I can find this email real quick, and I'll tell you the things that I stated.
Are you talking about a suggestion for modifying the ordinance related to the scope of our activities?
It has to do with, I think, Section 5, Article 5, it's Article 5, under the Civil Service Commission. I can't remember what letter it is. But inside of there, there's several things that are listed, and one of them is we serve as an advisory role, and that would require us to become a decision-making role.
So to start, should we suggest that the meeting consist of that, the ordinance and the changes being pulled up for all to review and discuss? Is that how we want to approach this? So, because it sounds like you're going on to specific language, but let's make sure that we're on the same page on what our agenda and approach
Yep.
is. Is that?
I think that the best approach, I think that you're going to get hugely bogged down if you're going to start trying to talk about ordinance language.
Okay.
I think, my recommendation is you come in, and I think you all go first, because you asked for the meeting, and I think you need to set forth, here are the two issues that we're here to talk to you about. First issue, the scope of our authority. Right now, under the code, we are advisory only, at least in terms of the discipline appeals. And we believe, a majority of us believe and have voted on, that we should have authority to review employee discipline. And so let's talk about that issue, without getting into the wording of what the ordinance is. And then they're going to ask questions, they will ask, me, what's pros, what's cons, which we've already talked about, and then you all will figure out what it is. And if at the end of that, the commission feels we want you to be able to have that authority, then the commission will say, lawyer, go draft that up.
Yeah, let's
And
look
then
at the
I'll
wording.
draft that up, and if
Okay.
you've got language that you want to, share of how you feel it would read, give it to me and I'll take it. And then that language would come back to you guys first, so that you could look at it and say, okay, yes, we'd like that, this is good language for us. And then it would go back to the commission for their consideration and adoption.
I agree. I don't think we should be discussing language at the meeting. I think we want to stay to what are we trying to accomplish?
So the two things we're trying to accomplish then, and tell me if I'm way out of line here. One is, if a person has been dismissed from employment for things that we find that don't comply with the personnel policy and rules, then we should be able to reinstate that employee. All right? And say if a
Well,
person.
so we have to be precise, and of course, this is what will be in the ordinance, but your finding is, was there or was there not just cause? That's the standard. And so subsumed within that is equal treatment of other people who were similarly situated, following the rules as they are written in the personnel policy, all of those things filter into, but the finding that you make at the end of your order will be, there was or was not just cause. Check one of those boxes.
Yeah. That boils down to two hearings that you guys have heard in the past, Mr. Telgo, where you actually pushed it forward to the city manager. City manager either sat on it or it just never made it to the Board of Commissioners. And even if I guess it did make it to the Board of Commissioners, there really is no way to overturn that decision anyway. Is that correct?
Well, so again, that we kind of talked about this before, the only employee that reports to the commission is that employee back there. And so if the commission truly felt that they wanted that employee to make a different decision, to undo a decision, the commission could say, we want you to undo this. And it would be his authority to say, respectfully, it's my administration, I don't want to. The option then for the commission would be, then you're fired, manager. But they don't have, they cannot get past the manager to make management decisions, and you don't want your governing board doing that. That's the model
So-
that's used.
We're asking, because it's things that like Happy Price and Mayor Hendricks and Doug Andrews have all asked for this in several of the Board of Commissioner meetings, that we actually have the authority to make those decisions. That's where we need to go back and ask, can we have this authority? That's the whole thing.
Yeah.
There's a thing in there too, if a person's suspended for more than 10 days, we have to decide, is that something we want to ask about? Because if you get to the point that you have excessive punishments, rather than firing somebody, they're just going to quit, which is not fair, and then they have a different appeal on top of that. So it's, at what point is a suspension without pay excessive? Is that something you would like to ask about, or is that?
I think that's a new topic. I would stick to, yeah. So
Stick
there,
just to the-
it's written out, I think maybe this is good. It's written out, two of them. Whoever, I think we have a summary in the last notes. Whoever is civil service protected, what are the due process steps they would like in place? Do they want to create a civil service commission empowered to order a reinstatement instead of the current advisory status? That was one.
Yes.
2, at what level do they want to cut off civil service protected employees versus people who serve at will? Do they want directors to be able to appeal? So those are the 2 primary items we want to discuss,
And
correct?
our vote on the last one was that we determined as a Civil Service Commission that we feel all employees should have the same protections through the appeal process, through the Civil Service Commission. So everybody needs to be, if they're going to be removed from their position, they have to be let go with just cause. They have to be dismissed for a reason. They can't just be done, go.
Yeah.
So no at-will employees.
No, I think the only at-will are the people that are above city manager, or city manager and above. The board-appointed positions are the at-will positions. I don't think we should ever have a say over those. That, the board put them in place. Why would we do that? That doesn't make any sense. If they put them in place, then they should make those decisions. Yeah, but, yeah. Yeah, yeah. But the reason behind that, and there are pros and cons, and I think you have valid statements in the things you said, right? Where I look at is when you look at longevity of people within positions, and typically you have a person in a director's position, they've probably been here for a while. They've been promoted throughout the ranks. They have a historical perspective of what's going on within the city. They offer a consistency. It establishes a rapport within the departments. They get this esprit de corps. They're all working well together. They understand what expectations are. But say, God forbid, Mr. Gomez ends up getting position working at the Florida, governor's office for whatever reason. That happens, that's cool, great, But another manager comes in and he or she needs absolutely no reason to dismiss those directors. That's just allowed to happen. Then you get rid of a lot of that historical perspective of the city and those things that have made and have established the ability to work and work freely and people not feeling uncomfortable in their positions. However, contrary to that, if that city manager tells a person that's in a director's position, I think that the city manager deserves a lot of leeway in telling a director, hey, this is a mistake, don't do it again. But it needs to be documented. If you come back the next day, 24 hours later, and that same person does something again, the city manager should be able to dismiss that person. Because the city manager needs to be able to run the city efficiently and smoothly, but not just dismiss because they don't like somebody. There
Okay.
needs to be just cause.
So we have 5 minutes left.
Yeah.
So for the meeting, I mean, I'm happy to have Jerry speak on behalf of the team, if that works. I mean, there's 2 points. One, the advisory position or not for us, right? We're lobbying to be more than advisory
But only to overturn decisions
pertaining to
to
termination.
to employees being dismissed for non-just cause. What do you call that? How did you phrase it?
Whether or not the management can show just cause.
Whether or not management can show just cause. I need to write that down.
But, subsumed in it is any level of discipline, just termination, because you were talking earlier just now about suspensions, and so we're going to need to be clear when we talk with the commission, if they do want you to have authority power, is that just for terminations, or is it for further down the food chain, and how far down do you go? I mean, if someone gets a written notice of counseling or something, so be prepared to talk about that. I don't know that y'all have debated that, amongst yourselves, how far down, you should go. And this is a small organization, and my sense is that there's not a lot of suspensions that are issued around here, but, you know, there is the practical effect that you all are volunteers and many of you work. And so if you start reviewing, you know, the further down you go, the more common they are. 1-day suspension, you could have 10 a year. And so, you know, you'll have to get, and this is a thing to keep in mind, if you do that, that is now becomes due process that that employee is entitled to. And so due process cannot be indefinitely delayed. And so it would be very difficult if that employee says, I want my appeal, and we're waiting 6 months to get a quorum of the Civil Service Commission. I mean, it happens because people are busy. This very same people who get appointed to these things are also prominent, busy people. And so just think those things through as well as you're coming for your ask. And in terms of speaking for the group, you know, just my political 2 cents, while certainly Commissioner Cantrell is the most articulate and researched on all this, I think it hurts you if you just let any one of you do it. I think the commission needs to hear from all of you so that they can understand that you're all of the same mind, especially Commissioner Tilka, you've got long historical experience. And so he could talk about theory, you could talk about here's what I've seen in my years when I've been on it. So you all have something to bring to the table. So when you're in this meeting with the commission, all of you all are free to talk, even if
Absolutely.
one of you is leading the pack, so to speak.
Yeah. And I guess I would just say, if you want to start off by summarizing the points and then have everybody speak, I think would be good.
Summary would be what we have right there.
Essentially those 2 points, right?
2 points.
Unless, is Clara, are you going to be providing any guidance or forum to the discussion?
Well, I'm putting all the minutes and everything in the packet for them to read and, you know, all your conversations and all. And the one that the attorney had mentioned about how St. Petersburg, their civil service, and I put their little charter thing in there. It hasn't been published yet. But if they ask me any questions, I know I've invited former civil service employees, members that were on the board when Commissioner Tilka talks about what had happened in the past. We've invited them if they want to make comment. Anybody wants to ask any questions so they can explain.
So set the stage, if you would, if there's no.
May I set the stage that
Yes.
we do not want to review if somebody's received a counseling and then they want to bring that before, it has to be,
A high level.
it has to be the high level.
I agree with that. And
Are you guys okay with that?
Well, initially, we were talking about termination.
That's, where do you want the high level to be? Only termination, or, because that's what we need to stick to, is what we say. Is that?
yeah, I guess, and was there a meeting that we're running up against that we need to stop for at 5?
We have
or
a
was
meeting
that
at
just-
6.
We have
Yeah,
a meeting at 6.
Okay. So I can say, the question is, you know, we only discussed wanting to overturn terminations.
So let's stick to that.
Are we good to stick to that? I am.
Only
I don't
that.
need to look at suspensions.
I don't want to look at somebody saying, I don't like the fact that you got onto me because I did something wrong.
Yeah.
That's,
Okay.
yeah.
Well, and the reality is that if someone is getting multiple suspensions or whatnot, more likely than not, it's going to come to you eventually as a termination. And so then you'll be able to look at those at that time to say, you know, was this progressive discipline? Was it suitable, you know?
Okay. I
Understood.
think we're all aligned on that then.
Yep.
Can I just ask about
Go ahead, ask.
the at-will, the current at-will employees are director level only? Or what?
The way it's written, I think it goes, is it below director down to the manager or something like that, or supervisor? There's been a lot of discussions of where that's at.
So there really is no civil service protection, if you will, in terms of having to show just cause, because you all are only advisory. So right now, the manager can fire anybody that works below him that is not commission approved. I think the code, I don't have it in front of me, but like the finance director or whatever is directly appointed by the commission, which is a weird fourth thing because normally that doesn't occur. But but pretty much there is no appeal. You can be fired for a good reason, a bad reason, or no reason at all. In that, there is no appeal. And so there's just your advisory thing that you do now. But all you're doing is advising the manager, and so the manager can, take your recommendation or not take your recommendation, but there is no overturn. So what I'm trying to say, and what I think you and the commission need to talk about, both need to think about, you all have already thought about it, but the commission needs to think about is if you're going to create a system where now you will be able to overturn a termination, then the question becomes more serious, at what level does that cut off? And I can't remember, Commissioner, if you were here when we, talked about it in more detail, but, the counter argument to reviewing everybody is that the manager has a core management team, and that core management team has to be on his or her page, and they may not, quote unquote, do something wrong or break a written rule, but they can undermine you and engage in politics and start to, make alliances with commissioners. And all of that undermines the manager's ability to run the administration. And so if at some point the manager says, this director is just not on my team anymore, I philosophically feel, just as me, that the manager should be able to call that person in and say, it's not working out, I'm real sorry, that we couldn't build a relationship, but I'm having to release you, without having to show just cause. And however you guys in the commission decide, it's fine, I'm a good soldier, but it's just clear-eyed, we need to go into this clear-eyed, that there is an argument on the other side, that line should be drawn at some level of executiveness. At Manatee County, that was division managers. So you had the assistant county administrators, the department heads, and the division managers. They were all at will. And then supervisors on down were civil service protected. But that was a larger organization. This isn't as large of an organization, so all that could be discussed and debated. But, again, I think that the argument is the core management team, the directors, I guess we call them here, should they have the right, if their boss says, this isn't working out, I've tried to work with you, you got to move on, should they put that on hold for perhaps a month or two while they're waiting for their hearing in front of you to continue to run their department, to come and decide if they should be fired? Or if they get fired, then months go by and you have an acting director, and then they prevail and you guys give the person their job back, and now they come back into the workplace, and now you have a department head who's vanquished the manager. It just creates a potentially real bad power situation. To be talked about with the commission, but that's,
So, I would actually tend to agree with you, Rob, on that point. So I'm wondering if we need to take that second step, just in terms of who is civil service, who is at will, but just, go in on a united front that we don't want to be advisory. We'd like this to have some, purpose that we're here and a meaningful thing that we can accomplish, which would be to review these, if you're dismissed. And that we do believe there's a level of civil service protected, that people can only be fired for just cause, et cetera. And then as
I
we're
don't-
working things out later, decide,
Well,
if we're not unified in terms of that the city manager should be able to
That's where we're,
decide who's
My
on his
impression is
team.
that you all aren't going to be on the same page as to where to draw that line. Correct me if I'm wrong.
Chair
but I-
Chair Embler agrees that it should be the director. All right, I think there was a mention that it should be manager in
There was
other
a-
conversations.
yeah, there
Well,
was
Chair
a
Embler
vote.
is, I think her term ends.
Yeah,
so
but
she's not
still,
even-
her thoughts are really valid and they're
Understood.
important. And that's,
I just think it's
She-
going to be better for you, since you're not really, I doubt you're going to get uniformity on that question. is it's better for you just to pose the more general question, should we review terminations? And then subset of that, commissioners, where would that line be drawn? And you guys can make your arguments. Obviously, you agreed with kind of what Chair Emler has kind of felt. The manager will have an opportunity, obviously, to speak his feelings on it. This is his administration, after all. And then y'all talk about it, and the commission will decide ultimately in what direction it wants us all to go, and then we will go follow that and start drafting.
Okay, sounds like a
But I
plan.
mean, I see it, even if the commission says, I'd really like to have the manager still have his directors be at his will, if you get everybody else being truly civil service protected and getting to come to you upon termination, that's still a huge victory for you, I think, you know?
Yeah,
Because the one case that you've been concerned about wasn't a director, it was a lower person and who
Yeah.
didn't get a fair shake.
excellent. I think we have a plan, or most of a plan. Okay,
So we're asking them to make the decision where to draw the line.
Well, they're the
we are
boss.
Yeah,
discussing.
that's it, yeah.
Yeah.
So hey, we'd like to have this.
This is
We're
an
asking
issue.
you to draw the line of where is at will.
Correct.
Okay, good? Call the meeting,
We're good.
meeting to the end. Anything else? That's
That was
it.
exciting. There we go.
Good, very good.